My name is Jacob. I'm present for pregnant.
The bill was coming up also for consolidation. The charge sheet is ready for the consolidation. So maybe we can mix mentioned together with 295, that is for Jesus Godua and Judith Batan Zioka. We have the running file being the 295.
The second one, then Jackson Apollo, then Alvin Odia. Let's start with Jesus. Jackson. Jackson Apollo. Section 317 of the Penal Code. On 30th day of April 2025 at Serena Hotel in Nairobi County, within Nairobi at Serena Hotel within Nairobi County, jointly with others before court and others not before court, conspired together to defraud to Shime Grace a sum of $116 equivalent to 15,360,000 by falsely pretending that she was in a position to assist her trading dinners, a fact to be false. True or false? Jackson?
False.
Alvin?
False.
Count number 2, obtaining money by false pretenses contrary to section 313 of the Penal Code. On 30th of April 2025 at Serena Hotel within Nairobi Court and others not before court with intent to defraud obtained from Tushime Grace a sum of $116 equivalent to 15,360,000 by falsely pretending that she is in a position to assist her trading denies a fact to be false. Jesus? True or false?
False.
Jude Jackson?
False.
Alvin?
False.
I don't know that for accused persons.
I'll continue to appear for the second accused person.
Regarding the third and fourth accused persons who are waiting for a bail court, probably go to those directions.
Place the file as it briefly because it also has a ruling which is supposed to be for the second accused person and also for pre-trial, so we can handle all the things together. So the matter can be placed as it briefly finish with the call over.
However, the investigating officer is in court. We can now with the investigating officer and the defense counsel so that they have the documents to do.
counts will have the bond terms for accused number 1 and accused number 2 remaining the same. The court has considered the pre-bail reports in respect to accused number 3 and accused number 4, which are both favorable. From the reports, accused number 3 and accused number 4 are first-time offenders. They have never breached any conditions for bail. They have strong family ties with fixed places of abode. Having considered the same, accused number 3 and accused number 4 are each released to a bond of Kenya shillings 2 million with a similar surety of the same amount, or a cash bail of 500,000 with 2 sureties to give a personal recognition of a similar amount.
Confirm whether you received our submission.
Yes, please, I did. Of May 2025, the counsel for the applicant made an application orally to have the money seized from the applicant, being Kenya shillings 200,000 and $600 together with her mobile phones, that is a Tecno Spark 10, iPhone 16, released back to the applicant. The court directed the defense to file a formal application, and the same was filed on the 11th of June 2025, and parties agreed to have the application and back by written submissions. The application dated the 5th of June 2025 is premised on the grounds that during arrest, the arresting officers had taken Kenya shillings 200,000 and $600 together with 3 mobile phones from the applicant, yet there was no nexus between the cash and the alleged offense. The applicant abandoned by the continued detention of her money and mobile phones amounted to a deprivation of property, which is under Section 40 of the Constitution of Kenya. The application was supported by an affidavit signed by the applicant on the 5th of June 2025. The application was opposed by the replying affidavit sworn by Beth Karaoke, who was the investigating officer hearing on the 24th of September 2025. In her response, the IO maintained that the money in question was recovered during investigation and was a crucial exhibit since the case at hand involved money. According to the IO, releasing the money will prejudice the prosecution of the case since it forms subject matter of the offense. The IO further stated the applicant had not provided any legal or factual basis to warrant the premature release of the exhibits which were yet to be produced before the court. In respect to the mobile phones, the IO stated the applicant had been requested to accompany the IO to the Communication Authority of Kenya in order to unlock the iPhone using the Apple Face ID in order to extract the relevant data, but she had declined. The IO requested the court to authorize the accused person to give her password, PIN and Face ID for the data to be accessed, and asked the court to order the exits retained in the police custody to await until the case is determined. Parties agreed to have the application canvassed by written submissions, and both parties complied. The court has therefore considered the application, the affidavit in support, the affidavit in opposition, and the relevant submissions by the parties hearing. The application here is premised on the Section 177 of the CPC, which provides prior apprehension of a person charged with an offence. Any property is taken from him. The court before which he is charged may order A, the property or part thereof be restored to the person who appears to the court to be entitled thereto, and if the person is charged, to be restored to him or to such other person as the court may direct, and B, that the property or part thereof be applied to be payment of any fine or any cost or compensation directed to be paid by the person charged. Under Section 121 of the Criminal Procedure Code, it provides that when anything is seized and brought to court, it may be detained until the conclusion of the case or the investigation, reasonable care being taken for its preservation. Looking at the above provisions, there is an exhibit to detain or to restore the property to an individual which believes to be entitled to it. However, the question begging will be, under what circumstances should the property be released? Procedurally, for an exhibit to form part of evidence, it has to be presented for purposes of identification, thus what the court inspects it prior to it being admitted or not, depending on its legality. Prior to the presentation in court, all evidence to be used during a trial must be preserved. This duty is bestowed upon the investigating officer of a case for the purposes of due process and fair trial. In this case, the IO has maintained the cash has been held as an exhibit. It should be noted that the offence at hand involves obtaining money by false pretenses. It's therefore clear that according to the IO, the money seized from the applicant was part of the money obtained from the complainant. It's only after trial can the court determine if this fact has been proven or not. If the cash is found to be lawfully acquired and not related to criminal activity, then the court can order its release. Several higher courts have held it to be an irregularity for a court to release exhibits prior to their production. In saying so, I'm fortified by the cases of Republic versus Martin Moroki and another, that is 2016 EKR, where the High Court in Meru held it will be proper to release cash exhibits before they are produced in court. Such release will amount to interfering with the prosecution evidence. In the case of Republic versus Joseph Ndongo Njao, that is 2020 EKR, the High Court in Kiambu held money being part of the subject matter of an offense cannot be released prior to its production in evidence and conclusion of a criminal case. In the case of Republic versus James Karanja and another, that is 2017 EKR, the court held that the court declined to release money alleged to be stolen, noting it was a crucial exhibit and releasing it would be prejudicial to the trial. Similarly, in the case of Republic versus John Kerry Waweru, that is 2018 EKR, the High Court in Nairobi held money seized as an exhibit forms part of evidence and must be preserved until it's produced in court. Its premature release would interfere with the integrity of the trial. Should the court order the release of the money seized from the applicant and it's later proven that indeed that money was obtained from the complainant, it would be greatly prejudicial, since by its nature, money is a liquid asset and can be utilized, unlike assets such as motor vehicle, which can be photographed and measures imposed to preserve the asset before the case is concluded. In submissions, the defense argued that the court has no glimpse on the kind of evidence the IO has. Even the money stolen electronically can be converted into cash, and without listening to the evidence, the court cannot tell if the money seized from the applicant has a nexus password, PIN, and Face ID for the data in her mobile phones to be accessed. I do believe this goes against the accused person's constitutional right to self. It provides that every person has a right to a fair trial, which includes the right to refuse to give self-incriminatory evidence. In the case of Republic versus Mark Lloyd Stevenson, the court held that it follows that any questioning or a listing of any documents or anything from an accused person without proper administration of caution or under circumstances which the rules of confession would apply is covered under the right to self-incrimination. I do believe the DCI Forensic Lab is well equipped to access mobile phones and extract data even without the applicant giving her PIN details and passwords, which will result to self-incrimination. The request by the IO is therefore declined. Being fortified by the decisions therein above, I do find it will be an irregularity on the part of the court to order the release of the money held as an exhibit before its production in court. However, for the mobile phones, it is only when the data has been extracted can the court give directions onto their release. The upshot of the following of the above is that the application dated the 5th of June 2025 lacks merit and is accordingly dismissed. So since we have some accused persons who are in custody,